You're listening to the Valley Current.
Welcome in. This is like a special edition of the Valley Current because we had a decision today from the U.S. Supreme Court, actually a series of them, because we're at the end of the term, which usually ends in June, but it's running into July because of the COVID-19 affecting their schedule. And I guess the Chief Justice fell down and hit his head. There's like all sorts of news coming out of the Supreme Court, U.S. Supreme Court in Washington, D.C. And there's a case that I thought was significant. I thought bringing in Professor Robert Acker, also known as Bob Acker. Bob used to be a lawyer back in the day when he and I were at Davis, Stafford, Kelman, and Fenwick that became Fenwick and West way back when. I don't know, was that 40 years ago? It was a long time ago, Bob.
Yes. I left 35 years ago. Yes.
It was a long time ago.
Yes.
And so I said, Bob, this is a case involving geography plus history plus law. So all three subjects in one ruling. And I'll put it on the screen just so people will say, oh, well, what are you talking about? We're talking about this case that got decided. I'll see if I have it on the screen. Yes, I do, right here. I could put it on the screen. It's McGirt versus Oklahoma, which was actually a case coming out of the Criminal Appeals of Oklahoma, a state court criminal appellate court dealing with a question of essentially federal law, which is, do state criminal courts have jurisdiction over someone who commits a crime on an Indian reservation? And it ends up generating this amazing historical review. What is it, like 83 pages of ruling, Bob, in total? I mean, it's amazing because it gets decided. It got argued in May. It gets decided today, July 9th. And it essentially goes on for what seems like forever.
Yes, doesn't it?
I mean, you tell me if it could have been done in less words. It's obviously a work of art by, I guess, someone who likes to write, which is a new justice, Justice Gorsuch, right? Wrote the majority opinion here.
Well, it's interesting that the entire argument, or Justice Gorsuch's entire argument, can be summed up in about 3 sentences, can't it? I mean, he basically says the treaty, the 1832 treaty, reserves Indian reservations as exempt from state law, certainly for criminal matters, and the law has never been changed, the treaty's never been changed, and therefore it governs, and that's the end of it, right? I mean, that's more or less his entire argument, and everything after that is whether the reservation, let's say the physical space of the, which tribe? I forget, Creek Indians, has ever been abrogated. And he says, no, it's never been explicitly abrogated, and so it's still there. And that's the end of it. And the next 35 pages are all about it's never been abrogated. So why do you think he went into it to that extent?
I don't know. I mean, I think Gorsuch was a law professor before he became a judge. And this has the flavor of, I'm going to write a law review article about what happened here historically. And, you know, law professors have this element of trying to track history. And you could argue there's a lot of history baked into this opinion that they probably did not have to get that involved in, but they did. Because you have to wonder, and I actually started to look into the underlying briefs that are available. Was this all sort of put to them by the people who did the briefing? Or did they on their own decide, hey, we're really going to do a full and complete historical analysis? Because you could argue that—
I think he and Roberts got into a one-upsmanship thing, frankly.
Oh, you think that's what happened?
That would be my guess. I mean, if I were Gorsuch, I would have been out of there in 5 or 6 pages, frankly.
Right. I mean, you could argue—
He doesn't need complication, does he?
Right. You could argue that if you look at this decision, which is joined by Ginsburg, Breyer, Sotomayor, and Kagan, that's the relatively liberal group of justices, right? So you got Gorsuch, who's a appointee of Trump, who everyone thought would be extremely—
his calling card was textualism, that you stick to the original terms of the statute. Yes?
Yes.
And that nothing else should enter into interpretation. So complication is what he really doesn't want. But it seems to me that textualism is a slogan rather than a way of deciding cases when you come right down to it.
Let's set forth for the people who are not as deeply into this stuff as we are. We're at the end of the U.S. Supreme Court term. The term has essentially extended for at least another month, maybe even further. I don't know. Usually ends in June. Usually they go on vacation until October. This year, maybe they're going to get some vacation in August. Gorsuch writes this very long-winded decision that starts with, on the far end of the Trail of Tears was a promise.
Exactly.
I mean, really, I mean, this is like, I think this could become maybe another Hamilton on Broadway. You know, maybe someone should take this and turn it into a 3-act play or something, right?
I was struck by that myself. The case is basically whether an Indian who was convicted under Oklahoma state law of pretty serious sexual crimes against a small child, right? Whether that conviction will stand or whether the state has no jurisdiction because of this background of Indian treaties. At the far end of the Trail of Tears was a promise, forced to leave their ancestral lands in Oklahoma and in Georgia and Alabama. The Creek Nation received assurances that their new lands would be secure forever. That was his first sentence, okay? Now, right. The first sentence of Roberts, dissenting and wishing to uphold the conviction, is, in 1997, the state of Oklahoma convicted petitioner of molesting, raping, and sodomizing a 4-year-old girl. So who's going to come out on which side of this, do you think?
Right.
Right. What I'm saying is it's more rhetoric and less analysis than either of them would want you to believe.
Right. So you could say the criminal defense lawyer did a great job, right? Because the criminal defense lawyer had to reserve this argument throughout the defense of this particular awful, probably very guilty individual, right?
I'm not sure if it was the criminal defense lawyer so much as the underlying sympathy that Gorsuch has for Native American issues, which he clearly does.
Right.
And which Roberts really doesn't.
So you're pointing out the way in which lawyers typically get through 80-odd pages of decision is look at the first paragraph of the majority decision and look at the first paragraph of the dissenting opinion.
Opinion, yes.
Pretty much can tell kind of what the difference is in the makeup of the court, right?
Well, to give background on literalism and originalism and textualism and all of that, does the Constitution or the laws enacted thereunder mean what the literal words of the Constitution say, or do you bring in all sorts of extraneous stuff, right? And if you bring in all sorts of extraneous stuff, then you've got this kind of rubbery Constitution. So that's supposedly a bad thing. So judicial conservatives have been pushing the textualist, originalist, stick to the text line, okay? So what's interesting is that the 4 conservative, I can use that term, justices, right? Alito, Kavanaugh, Thomas especially, and Roberts are going way, way outside the text to bring in all sorts of letters that were sent by Indians to congressmen in 1907 in their historical review that have nothing whatever to do with the treaty or the laws, right? So they're perfectly willing to go stomping all over textualism when it suits their purposes. Whereas Gorsuch wants to stick as closely as possible to the text, and the text says, you know, this is theirs forever, and nothing else counts.
Now,
but
why
let
do you
me
think...
point out, and then turn it back to you, Jack, because I'm interested to hear what you have to say about this. Let me point out, this is a treaty supposedly between equal partners, but the terms of the treaty are one of the partners, the U.S., can change the terms of the treaty whenever the hell it wants. What the hell kind of treaty is that?
Well, it's like
treaty is kind of a joke.
Well, it's kind of like an at-will contract, and in theory, there could be a renegotiation at any point, right? So you could argue that just shifting the question back to Congress. If Congress wants to change a treaty, Congress has to change a treaty, and presumably the Indian nation will get something in exchange, right? We'll get some something else,
You
not
can
Oklahoma.
presume whatever you want, but the point is the power is in the hands of Congress unilaterally.
Right. That's right. It is.
Yes,
But
imagine a treaty with Russia where, you know, they have the right to do whatever they want as long as they tell us that they're changing the terms. Give me a break.
But let's go back a little bit.
So let me go back to you now.
Yeah, let's go back for a second to the geography and the history. This case starts out with the deal. The deal that was made was that there were ancestral lands in Georgia and Alabama that they gave up in exchange for certain land that they were given in what's now Oklahoma. This is the way the nation sort of pushed the Indians further and further west, right?
Yes.
That's the story here. And the Indian nations are technically a form of sovereignty, like as though it's another country inside the United States. Lots of people are like flummoxed by that. How is it that we have a nation inside a state inside the United Nations? It's like if I said to you the Russian embassy in San Francisco, if it still exists, that's part of the Russian nation in the United States. Is that considered its own sovereign piece of land? Like, as a geography professor, what would you say about that? Like,
not a bad analogy.
Right.
I would say that if the SFPD wanted to go into the Russian embassy and arrest the consul, there would be a major problem about that.
Right.
Much more so than to any other establishment in San Francisco.
Right. Conceptually, we allow this idea of a political jurisdiction to reside on a piece of land denominated by boundaries. So outside that piece of land, all of presumably the laws that apply in that locality, that municipality, whether it's San Francisco or Palo Alto or, Los Gatos, is going to apply to whoever is outside that particular piece of sovereign space. We have in the United States probably thousands of different tribes, right, that live on different reservations. They are like separate nations inside the United States, inside those states.
Under the Gorsuch interpretation, yes. Under the Roberts interpretation, that's all been so attenuated that there's hardly any point in paying attention to it.
Right, but Gorsuch got the majority vote here, so Gorsuch is the rule of law, right? And what surprised me, and it's a long way of saying, I would have thought Kavanaugh would have joined Gorsuch on this, but he didn't. Kavanaugh is the youngest justice.
That's what I was saying.
Right.
All the originalists and textualists, forget about that. We wanted a different outcome. That's the long and the short of textualism as far as I'm concerned.
So you're saying,
back to you.
You're saying Gorsuch bended to, hey, this guy is guilty, man. This guy's totally guilty. We can't let him get off, because how is federal law now going to somehow apply to this criminal? How is that supposed to work? I don't really get what happens to the individual here.
Well, there are federal courts in Oklahoma, and the complaint will have to be brought in federal court. That's all.
But isn't it like from 10 years ago? How does that work?
Well, now you're beyond me.
Right, now we're in criminal law. That's why I'm saying it's a weird set of circles.
23 years ago.
This geographical move that causes essentially a historical deal that's embodied in a treaty. The treaty is the supreme law, right? Maybe the Constitution is the super supreme law, but the treaty is supposed to trump even statutory law, right? The treaty is like a higher body of law than even a statute, right? If you think about the scheme of things.
It's a higher body of law, but it can be amended by congressional enactment at any time.
Okay, but
and what Gorsuch says about going forward, about the consequences are, they'll be whatever they are. The Creeks and the Oklahomans will have to come out with some deal, and if they don't, Congress can always step in and do whatever it wants.
Right, but usually that takes a negotiation, even though they have that power.
Negotiation first, yeah.
There'll be some negotiation because they'll want to make sure there's not some sort of political storm and some sort of Custer's last stand kind of, you're going to have to come in here with guns a-blazing, right? Like, what was that guy, Waco, Texas? You're going to come in here and shoot me out of my compound? Like the Indians can say, you're going to come in here and take the last living man out before we give up our land, right? Or give up our individual.
I'm not clear about what my first thought was. Are land titles affected? Can the Indians now start taxing oil in Oklahoma to a fare-thee well if they feel like it? I mean, those would be the consequences I would turn to.
Well, couldn't the Indians say we're a separate nation, and on our land, if kids want to get married at the age of 14, we allow that as well?
Yeah.
And
if they want to ban alcohol on the eastern half of Oklahoma, they can do that. That's conduct. And if they want to change the zoning law such that, I don't know, I'm trampling on other constitutional provisions here. So if they want to change land titling such that Indians have preference to land, can they do that? I mean,
there's a lot of ramifications. This is probably in many ways
ramifications.
I mean, this is like the kind of case you would give to an advanced constitutional law class. This is what now knocks down a lot of dominoes around if the Indian nations.
But the bottom line is, if the Creeks were crazy enough to say only Indians can own land in eastern Oklahoma, Congress would knock it down that very day, right? So in fact, they don't have the power to do that.
Well, I don't know. I mean, at some level, we're sort of questioning now, what do you imagine is going on inside that tribe in Oklahoma? And then more broadly, what's going on inside the 1,000 other tribes that are saying,
figuring out how much more they can get away with when they're dealing with their respective states, of course.
Right, because in many ways you could say, well, Nevada has legalized prostitution on a state level. But now Oklahoma can say, hey, we lose a lot of traffic to Nevada, and we want to bring traffic to our casinos. Maybe we legalize prostitution on Indian land. No, can't do it?
Well, they can if the Indians let them do it, but the Indians can put a stop to it.
No, but if the Indians decide
if the Indians said that.
Yeah, the Indians.
That's regulating conduct. That's up to the Indians, yeah.
That's what I'm saying. I think if the Indians are sort of money oriented, like, hey, Trump turned Atlantic City into.
Like they want to open a casino. Could that ever happen?
Yeah, they open.
Yeah. Where do you think these casinos come from? This same body of law. Yes.
Exactly. So if they said, now we have 1,000 or more different tribes, maybe there's more, maybe there's less. Those tribes each say, hey, for our piece of dirt, we can actually do some really interesting things, like maybe even we'll copy Disneyland and say the intellectual property laws don't apply here. We're going to have our own Disneyland.
That's federal.
So what? Let them sue us.
Only state laws are implicated in this decision, though.
Okay, so you're saying it has to be solely and strictly something that would otherwise violate state law because state law has no reach here, right?
Apparently, yeah.
Okay, because I'm wondering what the limits are of what they could do. Clearly, things like prostitution are state-governed, typically state-governed.
Yeah, zoning, tax, conduct, all that is kind of up for grabs. And the only thing Gorsuch says about a limiting principle is Congress can backstop anything that happens.
Right. So let's take the really extreme case. They could decide to say that polygamy is legal on an Indian land because they're a sovereign nation and they believe that it's appropriate.
Yeah, if they want to make the age of consent for this little girl, they could do that, yes.
Yeah, I mean, I think Congress would have a word to say about that.
Yes.
Sure, right?
So the limiting principle is a real one. It's not going to be anything goes. But if you were representing an Indian tribe, you would be hard at work figuring out what you could make out of this, wouldn't you?
Right, because somewhere in this, you could say the Indians were just given new power by a Gorsuch majority, basically a bare majority, but a majority nevertheless, to say, look, these treaties have meaning. They've not been abrogated. And you can basically do what you want to do. And the criminal laws are not going to reach your people, not state criminal laws. And that's the way it goes. And if Congress wants to come in and do something different, they've got to come in. But this is a Congress that's pretty divided. So it's probably not the highest priority out there, right?
Yes, and it's clear that the Democrats who control the House are not going to lean very heavily on Native Americans at a time like this, isn't it?
I mean, I would think that if you look at this from the point of view of others who have been displaced, like Eskimos in Alaska, they've got to be...
I don't know. Do they have reservations?
Well,
I mean, that's what it turns on, whether there's a treaty.
whether there's a treaty, but I think somewhere in this you could start to wonder whether there are other groups of people that are saying, wait a minute, did we get left out? Did we get left out? Do we have some power that needs to be sort of asserted here? Because maybe this was a very dormant kind of thing that's been ignored up to now, but this one weird criminal case has brought it all to the head. And now we've got a decision that really probably will be in the case books in terms of major constitutional or major treaty decisions.
Let me pick up on that last point. It's a brutal case, but it's not a strange case. It's just an Indian being convicted under state law. It must happen 1,000 times a year. Yet this is the only time that this argument has been put forward on behalf of the defendant. How do you explain that? I don't.
I mean, you could say maybe they made a mistake taking certiorari. They didn't have to do it, right? They could have just let it go. I mean, in a way, they didn't have to decide that they were going to decide this issue. They have a lot of power to decide whether to decide this. The previous version of this was a 4-4 split with Gorsuch abstaining because he was in the 10th Circuit for that case. So they could have said, look, we just don't want to deal with this hot potato, but they decided to deal with it. And in any event, and frankly, that had me scratching my head because it seemed to me they could have just left it ambiguous. Right?
There again, it's because Gorsuch wanted to, basically, isn't it? And that relates to his sympathy for the status or the plight, however you want to put it, of the American Indian. So textualism, give me a break, is my bottom line. Judges are doing what they want to do, just as they always have.
So you take it as Gorsuch comes on the court, realizes there's a lot of pieces of business that he couldn't really get to as a Court of Appeal judge on the 10th Circuit out of Denver, Colorado, right? Because the Gorsuch family, by the way, is a big family in Aspen, Colorado. They kind of like own that town. It's like a Gorsuch hardware store. It's like a whole Gorsuch family story there. They're apparently great skiers as well, if you want to drop some footnotes in the story. But here's a guy that was a law professor who becomes a judge, then makes it to the U.S. Supreme Court vis-a-vis Trump. Trump probably thinks he's like the best, most conservative person.
Trump has no damn idea about traffic court judges, let alone appellate judges. He's taking what the Federalist Society gives him, that's all.
Oh, there you go.
I mean, the ironic thing is that Republicans defend the crazy Trump administration because of judges, but any Republican president would have gotten their judge list from the exact same place and probably the exact same list.
So I always wonder when I read these lengthy opinions that are followed by lengthy dissents, whether there was somebody going back and forth on whether they would join one or the other as the majority decision. You know what I'm saying?
Well, who's up for grabs?
Breyer.
You think so?
Probably would have been Breyer. It would be my guess because look at how this looks, or Ginsburg, because look at how this looks. Ginsburg is essentially letting somebody go who raped a 4-year-old, right? Think about this. The state of Oklahoma convicted this guy McGirt of molesting, raping, and forcibly sodomizing a 4-year-old girl, his wife's granddaughter. I mean, give me a break. This guy has no equities here. You're Ginsburg. You're one of the most liberal people on that court, and you're like joining the majority decision. I mean, think about it. Maybe you'd say Sotomayor would go the other way. I don't know. It's
well, if you go that way, I mean, brutalizing a very young female, then any of the female justices would be appalled, you would think. But there are other considerations. What can I say?
Well, you wonder whether they could have tried to draw some exception around some brutal crime or something, but maybe that makes no sense, right?
I mean, they're interpreting something called the Major Crimes Act. All the cases are going to be major crimes, let's face it.
So what did you make of Thomas dissenting based on...
I thought that was funny.
Based on a disagreement with a footnote? What did you make of that? He disagrees with footnote 9.
I wonder whether he has a bad conscience about so trampling on the idea of originalism, so he comes up with this totally out of left field, I mean, conceivably, possibly justifiable, but really minor point about exhaustion of remedies on the state level, and so we shouldn't have taken the case. Gee, thanks, Tom. I mean, come on. That tone, by the way, was unintentional. I didn't.
No, I know.
didn't
Justice
imply anything.
Thomas writes a dissent. At least you could say it's short, but it's all about disagreeing with footnote 9. I write separately to note an additional defect in the court's decision. It reverses a state court judgment that it has no jurisdiction to review.
Well, again, I say for very shame, you can't be an originalist and support the Roberts dissent. You just can't. It's not within 100 miles of the text. It's bringing in, letters to Indian commissioners 50 years later. Give me a break, okay? So it seems to me he's looking for some other basis on which to justify his dissent from the Gorsuch opinion.
So he must have initially said we shouldn't even take this case. That's my reading.
Yes, please get this thing away from me.
Right.
But in fact, this whole argument about originalism and textualism and yada yada is just bumper stickers and slogans as far as I'm concerned, frankly.
So let's summarize a couple of things for the law students that might be listening. And this is the kind of decision that you could spend hours and hours reading and decomposing and trying to understand and trying to figure out. And it might just be that it's just something where there's more politics involved than there actually is any form of principled approach. And you don't necessarily get that in law school. They want you to believe that there's a consistent set of approaches that constitutional scholars and justices of the U.S. Supreme Court use. Of course, the casebook is like thick, full of decisions like this. And as a law student, making your way through 3 years of law school, you embrace all of those opinions, trying to detect some thesis for how a court rules based on a constitution, which if you saw the film version of the Disney Hamilton, that's the hip hop version of how the Constitution got created. It's worthy of watching it just because it's so relatively entertaining version of how our Constitution got created.
Yes, I should add that I'm a total realist in the sense of realpolitik. I don't believe in principles. I don't think they exist, really. And this is as good an example of this as you can ever find.
So let me ask you something, just to wrap up with you, Bob. You're on your way to Laos. Am I remembering
Hopefully.
this? You're headed there for retirement. Do I have that right?
Yes, except I'm coming out of retirement. I'm retired now, but I've got a job at the university there.
So you're actually going back to work at a university in Laos, near Vietnam, where you fly like 40 hours or something to get there?
Well, it's more like 24 or 25, but I'm used to it by now. The problem is the only way to get to Laos is via Thailand and Vietnam, both of which are closed, so I couldn't get there. And if I were in Vietnam or Thailand, Laos Civil Aviation Authority is not having any passenger flights either. So I'm stuck here at least for the balance of this month, and it could be another 2, 3, or 4 months for all I know.
Okay, but you would otherwise be teaching at a university?
Otherwise, I'd be starting the new term in October, and I'd be entering into a contract to build my beautiful teak house overlooking the Mekong on 1/3 of an acre. On property that's going to double in value every 2 years.
Double? I thought it was going to quadruple. What do you mean double? I heard that it was going to go up 4 or 5 times.
Oh, it is, but over the course of 4 or 5 years. I mean, we have to work our way slowly up to this.
But you're building this from scratch. Literally, you bought the dirt.
Yes.
You bought the dirt.
Yes, I sent you the plans, I think, yes.
So conceptually, you're going to do a construction project while living in a local hotel?
Yes, not a hotel, an apartment, but yes.
In an apartment, while you teach at the university in English?
Yes, well, it's teaching English, so it'll be partly in law and partly in English.
Okay. Teaching law or geography or any?
No, teaching English.
English.
They don't have a geography faculty.
Okay.
And everything there is very top down. You have to fit into their existing boxes, no exception. If this were Cal, I would set up an independent study and do whatever I want, but they don't have independent studies, so I've got to do what I'm told, basically.
Right.
Very top down kind of country.
So you think that's going to work for you?
It'll be fine.
But let me ask you.
It'll be fine. I've also got a guest lecture series set up where I can do my own thing. So I'll be cool.
Okay. So if you tried to explain this decision without getting into textualism, but just tried to explain the background facts, your students in English. So we have
It would not be that difficult because Laos has a great number of minority ethnic groups. I think 50. even though the whole population of the country is 6 million, but there are 50 of these little groups. And I would simply say, imagine if the Khmu or the Hmong were given the right to own their own territory, and the provincial authority, like the Vientiane province or Udomse province, could not have jurisdiction. Could you imagine that? And they would say, yes, we can. That would not be a stretch.
So you're saying there is an analogy that extends even into Laos of the potential for a particular ethnic group to be treated like its own little separate sovereign sub-nation.
I don't know that they do that because, as I say, they're quite top down, but it would not be hard to imagine that the ethnic group could be a separate entity from the provincial authority, because
Right.
they have ethnic groups and they have provincial authorities.
Right. So the analogy I want to close with is arguably Hong Kong had that notion of separate sovereign status.
Used to have,
right. This is the point. This is the point to end on. Hong Kong was a colony of the United Kingdom for the longest period of time. You could argue the United Kingdom let Hong Kong be almost its own sovereign for a very long period of time. Where Hong Kong,
I thought you were going someplace else. I thought you were going to say that Hong Kong in relation to the People's Republic,
I'm going there.
is like the Creeks in relation to the United States.
Yes.
In other words, regardless of the provincial authority in China, the U.S. Congress can change the relationship with the Creeks at any time,
Yes.
just as the PRC just changed the relationship
Exactly.
with Hong Kong.
That's where I was going, but I was setting the contrast up where they probably were better off with the folks in the United Kingdom sort of having them as a quote unquote colony, because they had more freedom as a colony than when the power was turned over by the United Kingdom to China. And then China sort of let them be sort of separate for a while, but now has put the hammer down and said, you know, sorry, we're not doing that anymore. And the people in Hong Kong are like, wait a minute, you can't do this to us. We're separate sovereigns, right?
I don't know whether the UK ever could have done what the PRC is doing, but whether they ever would have done is a totally different matter. They certainly were not going to send what's left of the British Navy to the South China Sea to take over Hong Kong.
Right.
So
Right.
in practical terms, obviously they were better off.
Right. So I want to relate that back just as in closing that right now Disney on Disney Plus, you can watch Hamilton without spending $1,500 a seat and going to Broadway. Broadway's closed anyway. And you'll get the flavor of the same story. The United States as a colony of the United Kingdom, and the king sort of saying, what are you guys doing? You really want to leave us? Are you crazy? You know how awful that's going to be if you don't have the direction of somebody as smart as the United Kingdom? It's a great story, and it does tell a lot of history, but the pattern is very similar, which you could argue is there are these groups that do not want to be governed by other groups. And they tend to say, wait a minute, we have rights. And the ultimate question becomes, who gets to adjudicate those rights? And this case, McGirt versus Oklahoma, is sort of an example of how it can actually play out under some notion of the rule of law, namely what the treaty says is what the treaty says. Thank you very much. Case over. I mean, you're right. It could have been written in like 3 paragraphs, and it would have been a very short decision, probably with a very long dissent.
My historical question would be this. When the treaty was originally negotiated and ratified, I don't think it said that Congress can do whatever the hell it wants from now on.
Right.
I mean, that's not a treaty.
Right.
At some point, Congress assumed the authority to do whatever it wanted. When was that point reached, and what did the Creeks say about it at that time? I really have no idea.
Well, I think it's
at that point, it changed from a treaty to, what would you call it? Agency relationship, kind of, yeah.
It changed from a real treaty to something that was more at will, but I think the truth is the custom and practice of even these at will notions is we are going to somehow give you something in exchange to not create political turmoil with you, you know, the disagreements that will otherwise ensue, kind of thing. So we'll see how that actually plays out, because Congress could take this up and say, wait a minute, we're going to reverse McGirt versus Oklahoma. We don't want a bunch of kids getting raped by wild and crazy people that are on reservations.
Well, there is still federal court. I mean, these people are not exempt from criminal prosecution.
Right. But the federal courts are already trying to shove work back to the state courts, so it's not a great time for the federal courts.
No, various people will have to staff up, obviously.
Right. And you could argue Roberts might be more concerned with the federal district courts in Oklahoma being overloaded by state criminal cases that would otherwise be the budgets of the state courts, and him saying as the Chief Justice, we can't let this happen, period, full stop, because every one of those 50 states may have a tribe that'll do the same thing to our federal court system. We don't have that many federal judges. There's only 6,000 federal judges that are running the federal court system, including...
Well, they say Oklahoma is 12 or 15% Indian, and most of these people now live on Indian land, since most of the state is now Indian land.
Yes.
So 12 to 15% of the criminal cases are now going to be transferred to federal court. That could be a lot.
Right. Thanks for making your way here. I appreciate you doing this on short notice. I think it's a really interesting subject. I'm sure there's going to be a lot of commentary. We've opened the door. We'll try to get this out there very quickly. We'll hope that you make your way to Laos and tell us about how great it is there. And
please send me a link to this little chat so I'll circulate it to my pals.
I think it'd be fun. Anyway, you take care and you have a safe trip whenever you actually get your way out.
I'll let you know.
I'm predicting that you're going to make it to Thanksgiving and say you're having Thanksgiving with us, but I could be wrong about that.
Well, Tahiti opened up just yesterday, according to you.
There you go.
Who knows?
You never know. See you later.
Tune in next time on The Valley Current.